Namaskar, I am Advocate Kunal Chandiramani, and you are watching Urban Lawyer. Today we are talking about something that many husbands and their families often feel. All the matrimonial laws are in favor of the wife, but what about us? Well, today I have some good news. A recent UP High Court judgment in a domestic violence case has opened a door for husbands to get relief, not directly, but through a very important route. Let's understand the situation first. In matrimonial disputes, meaning disputes between husband and wife, the law gives the wife multiple options. She can file 498 AIPC for cruelty by husband or relatives. She can file domestic violence complaint. She can file a maintenance petition and more. But what about the husband? Traditionally, his remedies are limited to Section 9 of the Hindu Marriage Act for restitution of conjugal rights and divorce petition. Not much else in terms of direct protection from false allegations or harassment. Here comes the landmark case. X versus State of UP. Facts of the case. The mother-in-law filed a domestic violence complaint under Section 12 of the Domestic Violence Act against her daughter-in-law. She alleged that the daughter-in-law had mentally and physically tortured her and even forced her son to leave her. Summons were issued. The wife approached the UP High Court, arguing, "The Domestic Violence Act is meant for wives, not for mothers-in-law. Therefore, the mother-in-law has no locus standi, no right to file the case." The High Court examined Section 12 of the DV Act. It says, "An aggrieved person may present an application to the magistrate." Who is an aggrieved person? Defined in Section 2A of the Act, any woman who is or has been in a domestic relationship and who alleges to have been subjected to domestic violence by the respondent. The court observed, the Act is for the protection of all women in a domestic relationship, not just wives. This includes mothers-in-law, sisters, daughters, etc. If a mother-in-law is harassed by a daughter-in-law while living in the same household, she can also be an aggrieved person and file a case under Section 12. Here's the relief for husbands. While you, as a husband, cannot directly file a DV case against your wife because the Act is gender-specific, your mother can file it if she is a victim of cruelty by your wife. This means, if your wife harasses your mother, mentally, physically, or emotionally, your mother can file a DV complaint. This can bring legal pressure back onto the wife's side and give your family a defense tool. Important. This right is not available to fathers-in-law or to husbands directly. It applies only to women in the family who are aggrieved persons in the domestic relationship. So, to summarize, yes, husbands have limited direct remedies, but through this UP High Court ruling, the mother-in-law now has a recognized legal right under the DV Act. This can be a powerful defensive and strategic move in matrimonial litigation. Remember, every case is different, and winning or losing depends on the evidence and facts. But now, you at least have another arrow in your legal quiver. I hope you found this useful. If you have questions or need legal advice, drop them in the comments. Don't forget to like, share and subscribe to Urban Lawyer for more updates on law and rights. Jai Shri Ram.